Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in this session I want to talk about coming out of lockdown, which I think for a lot of employers is probably going to be a lot harder than going in. I'm going to be talking about some broad themes. This is because everything is going to depend on the facts of a given case. So it's very difficult to sort of give advice that covers everybody. You are going to have to think about things on a case-by-case basis. But hopefully this little video will give you some themes to just start thinking about the things that could be coming into play when everybody comes out of lockdown. Now, the first theme is around trust and confidence. I think employers sometimes forget that it's a two-way street, trust and confidence, and actually primarily it's a duty that the employer owes to the employee, and it's a fragile thing that can be broken by the employer if they get it wrong and they're perceived by their employees as doing something that's unsafe, or that they're not being listened to, or their complaints are not being heard, etc. So underlying everything that we say about any other topic, there is going to be this ingredient that employers are going to have to think about their behaviour towards their employees and make sure they're not doing something that would give the employee grounds to say their contract of employment is broken because the employer has breached that implied term of trust and confidence. The second broad theme is around data protection, and it can be very tempting to focus on the employer's needs to obviously protect the rest of the workforce from potential spread of coronavirus, etc., and forget that if we are taking measures or we are sharing data about somebody's health, which of course is sensitive personal data in old money, or special category data in new money under the GDPR, that we're interfering potentially with people's privacy rights in relation to their data. So we need to think very carefully about what we're doing with that health data when we're asking staff about their health, when we're asking them to talk to us if they've had symptoms, where we have somebody who has been symptomatic perhaps, where we start talking to other people in the workplace about potential risk and spread. We've got to be very, very careful around that area, and in particular I think be documenting what we're doing and looking out for guidance from the Information Commissioner's Office, because I'm sure that will be forthcoming. So that's another broad theme. The next one is health and safety. I am sure you will be undertaking risk assessments left, right and centre, unlike perhaps ever before in respect of this issue. You'll be familiar with the process of undertaking a risk assessment, or you should be. I would have thought this is an area where employees may actually ask you for your risk assessment. It's not a question we usually get from people, but pregnant workers in particular are going to be concerned. Everybody potentially may want to understand what you're doing to minimise risks to them in the workplace upon their return. So as much communication as we can make around that to make people feel safer and reassure them as to the steps that are being taken. And I think it's the small things that are going to matter here, the things that perhaps a sort of wide risk assessment might not pick up. So have we walked through the tasks that somebody has to do on a day-to-day basis, the places that they move to within the building, how that's done, who they're working with, how they do it? Have we actually walked through and picked up on where those risks might come in? It's important to remember that if somebody raises concerns about health and safety, they are protected by the law. If somebody suffers a detriment for having done that, so maybe they're not paid, or maybe they're disciplined, or other negative treatments, maybe they're not given the hours they wanted the next week or something, those people will be entitled to bring a claim for detrimental treatment. And, you know, employees might not normally have been aware of their rights, but I imagine it will be an area which is talked about a lot in the press, on the radio, and that people become more aware of their rights in that regard. And of course, the law does protect the person from dismissal if they've left work because they felt there was an imminent danger. So if you've got people who are refusing to come in because of a fear of the lack of arrangements perhaps to protect them, they would potentially be protected by that legislation. So we've got to be very careful before we dismiss anybody or we get ourselves into automatically unfair dismissal territory. And of course the whistleblowing legislation is going to protect people as well. So if they've raised concerns, health and safety is one of the types of information that somebody can raise with their employer that receives protection. And again, we shouldn't be treating anybody detrimentally or dismissing them for having done that. So that's going to be a big theme, I think, going forward through things. In terms of other things, consistency is my final theme that I wanted to talk about. How we choose who comes back, how we choose who stays perhaps working from home, how we deal with people who don't want to do something, want to have adjustments made. We need to be careful about consistency because, of course, discrimination is always lurking in the background. Particular areas, I think, of concern in relation to coronavirus will be maternity-related discrimination, disability discrimination, and age discrimination. So I think we need to have in the back of our minds that if we are making choices about how we do things, that there are potential candidates who might be able to bring a complaint. That's probably enough to give you the broad themes. If you do have any questions, please do contact me, adenton@refreshinglawltd.co.uk, and I look forward to speaking to you again.